Please this honorable court, I am Richard Kudici. I am court appointed for my client Duane Marquis Lucas. Your honors, I felt it was important this morning to come over and talk on behalf of my client. We start out with a scenario that no one is going to look lightly or favorably on. It's a horrible situation. Indeed, many people have suffered and were greatly affected, and that's demonstrated in the sentencing record, where family members came and where the emotions were extraordinary and where everyone spoke so highly of the deceased. I'm here to speak on behalf of mitigation for my client, Mr. Lucas. In this instance, we have a situation that cannot be avoided. It's not something that can be forgiven from the law, and that punishment must be exacted. But what we start with is the admission by my client that he murdered Brittany Littlejohn on February 21st, 2017. And he did that by way of a plea of guilty on February 23rd, 2018. He pled to murder with a firearm specification in count 2, and domestic violence in count 6, and weapon under disability in count 7, and a possession of cocaine in count 10. And on May 10th, 2018, he was sentenced by the Court of Common Pleas in Summit County, Ohio. He was given a significant sentence. He was given a life imprisonment with parole eligibility after 25 years, but he was also given consecutive sentences. So if you look then at the person, Duane Lucas, you're going to see things that were demonstrated by Mr. Lucas for this horrible act that he committed. You will see admission and acceptance of responsibility. You will see remorse demonstrated in the record and remarks made by counsel. You will see that as bad as it is, it may not be the worst form, if you will, of murder, if there is such a thing. And you will also see, when you look, that my client does not have an extraordinary history. He does have a history, but not an extraordinary history. So what I've come here to take this court's time, because I think it's of value, is the distinction between murder and domestic violence. With our claim to you that these two offenses are allied offenses of similar import in this case. So when we examine imposition of multiple sentences for allied offenses, if there is error, it is plain error, and that's pursuant to State v. Underwood and Criminal Rule 52B, as I've indicated in my brief. So in the plea of murder, count 2, what did Duane admit to do under the law? Well, he purposely caused the death of Brittany. And in count 6, what did he admit that he did? Well, he caused physical harm to Brittany. So if you look at the animus that goes along with that, the state of mind that a person must have, so we have an occurrence that is short in time and duration with similar mens rea, and we have the goal, the idea of animus to hurt Brittany, to cause her harm. The same conduct then is seen in a domestic violence causing physical harm and murder.
Except here the state is saying that that he was pushing her and doing stuff to her prior to him shooting her.
We do have that, Your Honor, so let's examine the factual basis of pushing someone. Well, is pushing someone domestic violence, first of all? So when
I've read many cases where it is.
it could be, and I give you that as a postulate. However, when the government says to me, well, you should have provided the PSI, well, maybe the government should have provided a PSI, because what we're doing is we're looking at the record. The record is what's going to distinguish the factual basis, And the factual basis for this claim does not support. So if we talk about pushing, well, maybe it is. So that's what she said. Duane pinned, pushed Brittany up against the wall. I mean, that can be many forms, but the whole purpose is similar to the goal. So the same conduct can be demonstrated, and Safety Johnson is the testing provision from the Supreme Court of Ohio. Can you commit both offenses with the same conduct? Well, yes, you can.
What about the break in time where Apple's brief states that the witnesses observed him physically attacking her prior to firing any shots, pinned her against the wall, went inside, returned outside, then pushed her and then shot her. So what about the break in time where he left her and then came back?
Well, that could be, but that's not supported in the record anywhere. The argument by the governor, or the state of Ohio is, well, there was a break, or we don't have that in the record. We don't have it as a factual basis. The prosecuting attorney did not articulate that at sentencing. So when we have sentencing, we're going to have a factual basis. There's nothing in the record to support the factual basis of that statement or assertion that the government makes in their appellee brief. So I acknowledge that as a concern, but the way I see it was, we don't know. He could have walked in the door, it could have been an occurrence of 2 seconds. He pinned her against the wall, he grabbed the gun. This is where we argue it's the same conduct, it's the same course of conduct, and it's not necessary I point out that it is not necessary under Johnson that commission of one offense will always result in the commission of another offense. So when we look at the offense conduct, here we're seeing similarities in conduct and act and also in animus. So the mens rea is same. It's purposely and doesn't purposely equal knowledge under this scenario here. So these are closely related offenses occurring from the same occurrence, and that's how we can advance today our assertion that the court failed below by not finding allied offenses of conduct in this particular instance.
Counsel, the only problem, the other problem with that argument is what you just argued to Judge Schaefer, is that the state has no record of anything they're arguing. There's no record, period. So it's your client's burden to demonstrate that he was sentenced on allied offenses.
Well, I would have to take exception in the sense that there is a record. The record is from sentencing. So if you look at the prosecutor's statement at sentencing, the factual basis would be that he killed Brittany. So there's no factual basis to support that he beat her up first, he committed domestic violence. Even though he pled domestic violence, he admitted attempting or causing physical harm, obviously, to Brittany by virtue of shooting her. And I think that's something that this court has the opportunity today to distinguish and speak upon. I think that Duane has a valid argument there to support that. And that, if you look at the next question from Johnson, were the offenses committed by a single act? And Judge Schaefer is saying, well, no, there was the break. But if we look at the single act was killing Brittany. So without support, either in a factual basis as recited, or questioned by, as you often have done, what did you do, sir or ma'am? And that's not supported in the record. And therefore, if the government wants a PSI that they think would demonstrate support for their position, is it the obligation of the appellant? And I say to you, it is not. So we argue that there's a single act performed by a single state of mind, under purposely and knowingly on the two, and that therefore you can and did in this instance commit both offenses as they were same occurrence and same conduct. So the next thing that goes along with a theory of allied offenses is here we have a weapon under disability and a gun spec. you cannot commit a gun-spec murder without having a weapon under disability. So it's urgent that the court takes a look at these arguments relative to allied offenses. It's just like, can you have a shooting in a habitation without having a gun? So there are theories, but I think this court has an opportunity here to define that clearly. You cannot have a gun specification and have weapon under disability. Now, the government will have you believe, well, he had the gun, he went and had the gun, he went and possessed the gun. Well, he had the gun and he used the gun. And that's why weapon under disability and,
Well, how can, that's always caused me question. If simply having a gun, you're not supposed to, is enough to get a weapons under disability charge, right?
yes.
But having a gun to commit the crime, is that one of the requirements for the crime that you committed, is to have the weapon?
No, because you can purposely commit certainly murder without a gun. However, you know, the example will be, well, so if you, the government, I mean, the prosecutor has argued, well, the two different events took place, and I'm saying in that regard, Your Honor, that how can you commit a gun specification without having a weapon under disability? So if you analyze it through Johnson, it's similar. Same conduct, same state of mind. State of mind was you possessed a gun, and state of mind was you used the gun. Now, the prosecutor will say, well, it's only a sentencing enhancement. It's only a sentencing enhancement. That's always the argument. The specification is not a substantive, it's only an enhancement. And I say, well, in this instance, it may be an enhancement, but it also is the predicate for the claim of murder. He used the gun to commit the murder, weapon under disability. So that's why we urge this court to consider that in the sense that it is a similar offense of conduct. And the argument might be analogous to all of my presentation here with, like, if you're choking someone. So if someone in a domestic chokes their girlfriend or their boyfriend, so here we have attempt to cause physical harm. On the same breath, they end up killing the person. Those are similar courses of conduct and similar events. I won't speak so much on the burden of what I consider an inappropriate sentence. Consecutive sentencing has to do with more towards the worst form of behavior. The record does not support the need for consecutive sentences, which ended up being a maximum sentence here. And I think the court erred when they granted consecutive sentences in this instance, because there was not sufficiency to support it, but the emotional condition in that courtroom, I just happened to be there, was, in my career, probably the most intense I've ever witnessed. And that naturally had an effect on the court, as well it should, but does that translate into consecutive sentences under the circumstances when a person is given 25 years to the board on a life sentence, plus on top of that, the additional consecutive means? So I would urge the court to review the notion of consecutive sentences in this case. Yes, the defense lawyer is going to come in and say it's too much, and others may say there can't be too much for murder, but we're here under the law, not under emotion.
Thank you, counsel.
Thank
Any
you,
other
Your Honor.
questions?
Thank you for, on behalf of my client, for taking the time to listen to Mr. Luke.
Absolutely. So we will obviously confer and come up with a decision that will